nearly dry. Well, good morning. Hope everybody had a wonderful weekend. Hope that you got a little rest. I would suggest that next weekend you do sleep in a few days. If you would, bow with me. Heavenly Father, again we come asking you to forgive us of our sins, to say thank you for the blessings of life. Thanks for being there for us in the tough times. Lead us and guide us. Let us have wisdom. Let us act with compassion. Lead, guide, and direct us. Forgive us of our sins. In Jesus' name I pray. Amen. Y'all passed any bills in the Senate yet? All 6 of them. We really appreciate those 6. How many you got left over there? Oh, 182. How many of them are in one committee? Oh, 70. And y'all want me to be nice to you. Mr. Douglas.
Good morning, and thank you, Mr. Chairman. Committee members, I have this little resolution, H.R. 1342, which urges Georgia schools to increase recess time. This will improve the students' physical and mental capacity and well-being. And that's it.
How much time you want to increase it to? 2 hours?
I would love to.
Oh. Well, let's put it in there. We'll pass it. We're going to urge them to do it anyway.
Yes, sir.
No questions. Thank you.
Thank you.
Ms. Buckner.
Good morning, Mr. Chair, ladies and gentlemen of the committee. I come to you today to ask for your favorable consideration of House Resolution 1382. It's the 4th bill down on the first page. We have had a number of our state employees and state, both retired and active employees, have concern about the cost of their health care plan, and they have asked to have a committee that is an ad hoc committee that provides input to the commissioner prior to the health benefit plan being selected. The commissioner has been notified. He said he could live with this, and I would ask for your favorable consideration.
Best Commissioner, can the governor?
I didn't talk to the governor. I don't have much access to him, actually.
Well, you change parties and you can.
We've had that conversation. Thank you.
Got no questions. Thank you.
Thank you for your favorable consideration.
Mr. Clark.
Thank you, Chairman, and good morning to the committee members. I bring before you today House Resolution 1564. It's just encouraging our schools to adopt a sudden cardiac arrest training. And with the number one killer, with it being the number one killer of student athletes and over 74% of students showing symptoms, it will save lives. And also it's a passionate topic of mine because I've lost recently in my district 2 young men to sudden cardiac arrest. So I ask for your favorable consideration of this resolution passing.
No questions. Thank you.
Thank you.
Just as a note, resolutions are a good 39-day something to do. Okay? My favorite senator, Mr. Bethel.
Thank you, Mr. Chairman, for clarifying. When you said favorite, I just wanted to make sure I appreciate it. On top of page 2 in your modified structured section is Senate Bill 193. I just returned to ask for this. It closes 2 loopholes with respect to an automatic aggravator for domestic violence offenders.
No questions. Thank you.
Thank you.
Mr. Tippins.
Thank you, Mr. Chairman, members of the committee. I'd like to ask for Senate Bill 364. fifth from the last in the modified structure. It's a little education bill that decreases the onerous requirements of testing in public education, puts a renewed emphasis on reading and mathematics in K through 5, and many other wonderful things that are far too numerous to go into. But the House has adequately vetted this, and I believe it's a good bill.
It is a good bill, no questions. Thank you.
Thank you, sir.
Mr. Kennedy.
Good morning, Mr. Chairman and members of the committee. I bring to you Senate Bill 333 for your consideration. It's number 12 on page 1, 12 down on the modified open rule. This bill, Mr. Chairman, deals with out-of-state nonprofit corporations. Currently, the problem is there's the code. Our code doesn't provide a good way for nonprofits in other states to change their domicile and move to Georgia, and it would be a good thing if they did.
Mr. Fleming.
Thank you, Mr. Chairman. To the Senator, is this the bill that we had where I think SunTrust actually came and testified that they were founded in Virginia, but they're headquartered in Georgia now, and they've got a $150 million foundation that they'd like to move to Georgia with employees along with it, if we could change our law to make it easy for them to do that? Is that what we're talking about?
Yes, sir, Representative Fleming, with I think maybe one minor change. I think what SunTrust stated was it was maybe a $330 million foundation.
Twice as large.
Yes, sir, they'd expect to move those funds to Georgia with a favorable change of this law.
And we hope others will do the same if we make it easy for them to come here.
Yes, sir, sincerely hope that they will.
No more questions. Thank you.
Thank you, Mr. Chairman.
I don't know you, Mr. Williams. Who are you?
Senator Williams. My name is Senator Michael Williams from Forsyth County. Thank you, Mr. Chairman, members of the committee. I have actually two bills to present. The first one is SB 275. It's fifth from the top on the second page underneath the modified structure rule. Currently, the State Board of Education has a policy that once a position has been voted on by the local school boards, school board members cannot speak out against it. This bill pretty much gives local school board members the right to speak their mind if they so choose to, and speak out against the policy that might have been taken. Also SB 356. This pretty much puts the onus of the burden for taking care of an animal that was impounded due to criminal activity by its owners on the actual owner instead of on the taxpayer. And those are the two bills.
Mr. Benton.
Thank you, Mr. Chairman. Senator, on Senate Bill 275, is there a particular school board that has done this particular thing, that has adopted policy that keeps its members from having freedom of speech?
It is part of the state's code of ethics that pretty much all the local school boards have adopted. So it's being perpetrated by the state school board.
In other words, to having a board spokesperson takes their, are you saying that takes away their freedom of speech?
In a way, yes, sir.
All right, thank you.
Ms. Jones. No more, wait a sec, Mr. Willard.
Thank you, Mr. Chairman. Senator Williams, isn't it not true that the language that we're talking about in the state proposed Board of Ethics standards, each board member has to sign a statement saying they will abide by that as a part of their ethics statement, and if they don't do so, they could be charged with doing unethical conduct.
That's very correct.
By having their speech limited in this case.
Sir.
Thank you.
Ms. Hughley.
Thank you, Mr. Chairman. I too have a question about Senate Bill 275. So why, I think the reason they have that is so that we would not have a lot of confusion as it relates to public policy regarding our children. And with this change, what do you expect to happen?
What I expect to happen is for local school board members not to be scared or intimidated into becoming silent or being silent. And if there's a position that's taken that a individual that is elected by the people feels is not in the best interest of those people that were elected, that elected the individual, to speak out against it.
Thank you.
Wouldn't you think that when they made those policies or rules, they got to express their opinion publicly on those things?
Again, that the policy is before the vote is taken, that they have every liberty to go out there and to state their position. But once a vote has been taken, if they speak out against it, as Chairman Willard mentioned, an ethics complaint can be filed against them and they'd be charged with it.
Again, they probably spoke out against it during the hearings or the meetings that they held with the rest of the board.
Very likely.
No more questions. Thank you.
Thank you.
Mr. Ligon.
Thank you, Mr. Chairman and members of the committee. There's a Senate bill and Senate resolution under modified open rule. First, Senate Bill 206 establishes a procedure where a commercial owner or tenant can determine if whether or not there's a water lien against the property, so they're not saddled with paying for someone else's water. And then Senate Resolution 730 encourages the state to support implementation of the Coastal Georgia Greenway, which is a 155-mile bike path that runs along coastal Georgia.
Up there on 206, how does it fix the problem of the building that has multiple tenants but one water meter, and then the owner of the building doesn't pay the bill?
It doesn't address that. That's set in current law, but this is dealing with more with a commercial situation where you'd have a new tenant, for example, that comes in and starts another restaurant. They don't know that there's a water lien, and their water would not be cut on unless they paid $1,000 or $2,000 bill that someone else incurred.
Mr. Willard.
Thank you, Mr. Chairman. Senator Liggins, is it not true that the purpose behind this is to have some clarity where you have what we call these super liens, which are unrecorded?
That's correct.
That no one has the ability to understand that there is an outstanding lien, but now you're giving notice to the local water department that you need to get this information as a part of the transfer of title to the property to be sure the person acquiring the property is receiving it free and clear of any liens, just like we do with taxes, just like we do with outstanding security deeds, anything that may constitute a lien against that property.
Yes, sir.
Is that the purpose behind it?
That is the purpose behind it, and you can send a request by certified mail to the water supplier, and they have to let you know if there's a lien against the property.
Because the people who could be harmed are really the ones who buy the property expecting that there has been everything cleared off as far as what may be actual claim against their property before they go through a closing.
Yes, that's exactly right, Mr. Chairman.
Mr. Knight.
Thank you, Mr. Chairman. And the intent of the bill, I think, is good. I just have a question to make sure that we're not loopholes. So if, in your example, say a restaurant owner has gotten delinquent, owed bills, or owed, utility bills, water bills, is there any provision in there that say they transferred ownership because it's a, some type of, entity,
yes,
to say a family member, so that constituted a new ownership? Could they get out of that? And in essence, you see where I'm going with this?
Right.
That loophole, that's the only thing I've got a concern about.
No, it would not allow, that would be a fraud, and it would not allow a fraud. If the bill is owed, then they would let the new purchaser or owner know that the bill is owed, and the new purchaser could either pay it or not buy the building or not lease the building or require the seller to pay it.
Okay.
It provides a mechanism for notice.
Okay. Thank you.
Mr. Willard.
Further, it's not true. It doesn't extinguish the debt. The debt is still there. They just have, the water department has to go against the party who incurred that debt, as opposed to now holding a party who has bought the property and sought to have a clear title.
Correct.
Become responsible for it.
Yes, sir. That is exactly right.
How do you get just
Thank
between me and you,
Please.
how do you get clear title to a property that has a lien on it?
How do you get a there's a provision in the law, Mr. Chairman, that calls it we call it a super lien. It's unrecorded, but the water department retains a right to go back against the property for an outstanding water and sewer bill, even though it's unrecorded. And there's just really one major department in the state that has a problem doing the right thing. It's right down the street here, but it covers a lot of properties. And what we're saying is, we'll give you a written notice requesting that information, and you give it back an answer to us in 10 days saying, is there an outstanding bill which may constitute a lien against the property to be cleared up at the time of a closing. Simple as that. If they don't do it, then they don't have a lien that they can claim against the property, but they still have an outstanding water bill. They can go back against the property owner for that bill. It's really a egregious thing to expect somebody to go through buying a property thinking they've got a clear title to it and then find out no, a month later, or they go in to get the water turned on and say, no, you can't get your water turned on until you pay a $2,000 bill.
Does this bill fix that?
It does.
What number is this? I'll be sure and get it on here.
This is the 206.
Okay.
Senate Bill 206. It really does. It's an important piece of legislation.
No more questions. Thank you.
Thank you, Mr. Chairman.
Ms. Chandler.
Good morning, Mr. Chairman and committee members. H.R. 768 is the first one on your list on the front page, and it is a call for a study committee to consider mandatory reporting, which has not been reviewed in over 26 years.
No questions. Thank you.
Thank you.
Mr. Walker.
Thank you, Mr. Chairman and members of the committee. I'm Larry Walker III. I represent Senate District 20, and I'm here to ask your consideration of Senate Bill 337, which is under the modified open rule heading. It's fifth from the bottom of that section. As Georgians, I know we're very proud of our men and women, Georgia residents that serve in the military. We appreciate all they do for us. This bill will help families of military servicemen and women that have a developmentally disabled child or a dependent needing medical assistance from the state, and they have a change of duty station, and that requires the dependent to move outside of the state. When they return to the state of Georgia, it instructs the Department of Community Health to maintain a registry of those people so that they don't have an interruption of service when they return to Georgia. It also allows Georgia residents that are serving in the military and have a dependent requiring medical assistance that are going to exit the military and return to their home in Georgia to go ahead and start the application process for that dependent and allow them to get in line for these waiver services.
Mr. Earhart.
Thank you, Mr. Chairman. Senator Walker.
Yes, sir.
Well, it's hard to say. Isn't it true, sir, that I received a call from a former member of this body, former majority leader, and asked me not to treat your legislation the same way mine was treated for the 15 years that he and I...
I'm sure the representative knows what he speaks.
And because of my esteem and friendship with the former majority leader, I promised him that you'd do much better than 15 years. I would assume. That's up to the new chairman, but I suspect that things are getting better.
Thank you.
No more questions. Thank you.
Thank you, Mr. Chairman.
Which one you got, Rusty? Yeah.
Mr. Chairman, thank you. Back here again on Senate Bill 168, just simply lets the old governor's mansion in Milledgeville be on the Georgia list of an historic house. Maybe I'm more lucky in being last than I am being first.
You know, we sit there and we're looking at making the old governor's mansion the official state historic house.
On the list of state historic houses, yes.
I have a little place up in Chatsworth called the Van House. I'm sure it's the state historical house too.
Yes. I think there's several historical houses in Georgia, and they put it on the list of tourism. There are several houses called the historic house, but it puts the house on a different national register list. So tourism coming wants to go see a historic house. They might not know the old governor's mansion is there, but they'll see it on the historic house list and possibly go from tourism. It's not the only one, no ma'am.
Again, it says as the official state historic house.
That's just the way it was given to me, or given to Senator Jones. I don't have it changed. I don't have a problem being changed to a Stickhorst house.
We probably need something that changes that "the" to an "and."
That's fine.
Thank you. No questions. Okay. On your desk, you have an amendment, Mr. Fleming, AM 360548. It's an amendment to a bill that'll be on the floor today. Mr. Fleming.
Thank you, Mr. Chairman. Members of the Rules Committee, we passed out the bingo bill, Senate Bill 316. There was some well-intended language in the bill that actually had a bad effect, and this amendment straightens that out. I worked with the Legislative Council, the District Attorneys, Speaker's Council, and of course spoke with the House sponsor as well. There was a potential problem with the Georgia Lottery scratch-off bingo game, and also a potential argument that we're opening the door for other things like video poker. But by scratching some of the language that was problematic and inserting the language in a different part of the bill, we solved that problem. I'd appreciate the committee's favorable consideration of the amendment.
I appreciate the fact that you caught that thing, because the video poker people could come back on that. So, again, you've got the amendment. Do I hear a motion? Any objection to having that amendment? Okay, it's on the floor. At House, I'll say this again, House members, your resolutions will be later on. Senate member resolutions could come out today. It's according to what we need to do. All right, never mind, who's 12? Ms. Smith.
Thank you, Mr. Chairman. May a member of the committee just put their name by a Senate resolution then at this time? Okay, thank you.
You have another amendment. AM 281505. Ms. Abrams.
Thank you, Mr. Chairman. As we discussed on Friday, Senate Bill 263 would allow sworn officers who've retired to retain their badges and their service weapons. The concern that I raised at the time was that this is currently limited to state law enforcement, and we would expand this to 159 counties and 580 plus cities. I spoke with the author of the legislation, Senator Thompson, and he has no objection to the amendment, which would simply require that we affix the word retired to the badge. Either it can be clearly marked on the badge itself or by an attachment that's permanently affixed to the badge. The concern is that you will suddenly have a proliferation of law enforcement personnel of every rank who would be able to retain these badges, and without proper oversight could use these badges in I think, an unfair manner, and this would simply allow them to retain the badges for the purposes of the historical preservation that they seek, but without creating any potential harm to the public at large.
You did say that you spoke with the author, Mr. Thompson,
I did.
and he's good with that.
He is.
You've heard the amendment. Do I hear a move? Wait a second.
I've got what concern are you worried about?
The concern is that you have folks who will pull people over and will flash a badge, and this, which is not to say that this will happen with everyone, but right now it's a very limited number of people who are allowed to keep their badges. We're about to change this to say that every law enforcement officer in the state and cities and counties, every law enforcement at the county level and every law enforcement in cities, constables, that they can retain these badges. And that's a lot of badges being retained by retired officers that could be stolen, could be sold, could be lost, could be used. Right now, the control mechanism is that they have to be turned in. We're saying that they can be retained, and unless we affix to it the word retired, there is no way to know that this badge is not a lawfully used badge at the time.
I think what it does, it allows the promulgation of policies. The locality can allow them to keep the badges if they so choose. My concern is that we're allowing them to keep it, this memento from their career in law enforcement, then we're going to deface their badge when they get to keep it, and it fundamentally alters the nature of the badge itself, and that's the whole reason that we want them to be able to keep it as a thank you for their service, their decades of service, and we're going to deface the badge with an emblem that says retired on it. That's I guess it's a policy decision. Your concern about the unauthorized use of badge versus how and whether the degree to which we honor these law enforcement officers by allowing them to keep this badge. So,
and I hear the concern of the whip. My concern is that we've balanced this in years past by not allowing. There's a reason people aren't allowed to keep their badges. There's a reason they are required to turn them in. We are about to fundamentally alter our promulgation of badges on the ground. And while I think there certainly is a level of respect that should be attended to, and I understand that, I think the word retired does not deface the badge. It simply signifies that the badge is no longer an active badge in use. It's a simple notion, and it can be affixed in a way that I think does not deface the years of service attached to that badge, but does provide service and provides security for citizens, because I'm from Mississippi. I'm from a community that is smaller. We've had people who have attempted to use badges, and I think that we can strike a balance between respect and security by fixing this.
Mr. Willard.
Thank you, Mr. Chairman. To Ms. Abrams, is it not true that what we're doing under the bill is making this badge going to the retired officer his property now? Is that not true? And is it further not true that upon his death, this badge will be then inherited by someone who's a member of his family or someone else, however it may be done? And as such, this badge could improperly be used by someone else other than that police officer one day to try and hold himself out as being a law enforcement officer. And all we're trying to do is be sure that that is limited and not capable of being done.
Correct.
Is that not true?
That is correct.
Mr. A. Powell.
Thank you, Mr. Chairman. I understand the amendment, but in the real world, when these officers retire, most of them frame their badges or they frame their guns, and there's already laws on the books that once they're retired, they cease being an active law enforcement officer, so then they'd be in violation if they tried to use that badge to perpetuate that they're an active duty law enforcement officer. And, quite frankly, that we have officers today that they retire after years of meritorious service and honorable service, and to deface them by putting a stamp on them or something like that, I mean, to me that would be sort of irrelevant, because somebody wants to impersonate a police officer, they can go to any nickel and dime store or internet or somewhere to pick up a badge. So I just sort of have a concern about why we would need to go this direction.
Ms. Ballinger.
Ms. Abrams, I know whenever I worked in and around law enforcement quite a bit more than I do now, a lot of them already kept their badges. And is it not true that, anybody can go to Amazon or the Galls catalog or law enforcement catalog and purchase a badge? There's nothing prohibiting anybody from purchasing any badge. And I think to deface a memento from somebody who has, honorably served the community is, guided.
Mr. Earhart.
No, I was just going to say, Mr. Chairman, I'm on Amazon Prime right now. I can get any law enforcement badge from any agency, anywhere, every city, every county. I can have it delivered to my house on my Amazon Prime account by tomorrow afternoon if I pay an extra $6. If I want to go out and impersonate and commit a felony for impersonating an officer, the badge is not the issue. It's the issue of the intent and the criminal activity the individual is doing it. So I don't see the gain by defacing a badge that somebody had in their pocket their entire life.
Mr. Fleming.
Thank you, Mr. Chairman. And this question is to the leader. I see on line 16 of the bill the word may adopt policies. And so rather than us automatically making every retired police officer having the ability to keep their badge, instead we're actually just allowing local entities, governments, and whatnot, who have these officers to make the decision for themselves. Am I correct on that?
The intent of the policy is to allow law enforcement officers who are currently not permitted to retain these badges to do so. And this bill sets forth the condition that allows them to do so.
But
Mr. Fleming, I'm trying to respond.
Certainly.
My amendment simply says that in the adoption of the policy, it will include the requirement that those badges have the word retirement. If you look at line 17, this is any law enforcement officer for a municipality, a county, or a school board. That means you are creating a proliferation well beyond GBI and correction officers and state officers. We are expanding this to 580 plus cities and counties, 180 school districts, 159 counties. And while I certainly respect the fact that not everyone will be a bad actor, it is our responsibility to anticipate potential bad acting. That's why we pass laws. And so my intent is not to deface or to otherwise demean, but to extend the protections that were intended early on by requiring the return of badges upon retirement. Not everyone is going to mount the badge on their wall. Some are going to keep them in their homes and in their pockets, and some of them may not use it to commit felonies. Some of them may use it to ease ahead in line or to do other things. And it is important, I think, for us to recognize that the standards, while they exist, it is the role of this body to balance celebrating those who've done good work with the protection of the communities that we are also responsible for. And this is a dramatic expansion of what is currently a limited practice.
But I guess the response to my question is yes, that if the city of Atlanta or DeKalb County or any other local government does not want to allow this, they don't have to. In fact, they have to proactively allow it. Is that right?
They may describe these policies, but these policies may not include a restriction. And so the permissive language is why I'm requesting that we include some level of restriction, because it is indeed permissive, and that permission can extend beyond what we intend in this body.
Mr. Setzler.
Mr. Chairman, I just wanted to try to divide the questions. I've listened to the discussions. I hear some of the discussions around people keeping their badges as a memento behind glass, and the minority leader's concern is one that is a badge that would be carried on the person and perhaps be shown if needed. I think, as I see this, I might suggest to the minority leader, and whether we do this on the fly or another day, I would maybe suggest adding a small clause to her amendment, provided that if the badge is carried on the person, the word retired, if someone wanted to carry it with them over time and maintain it on their person, I think that's what the lady's trying to get at. I don't think, though, to the majority whip's concern, if it's going to be behind glass and maintained, it needs to be, quote, defaced as such. I think the distinction would be around someone who's going to continue to carry that badge. Perhaps only in that circumstance would they need to have a retired designation put on it. So I would offer that to the lady.
Mr. Knight.
Thank you, Mr. Chair. My question is how can you permanently attach the word retired to a badge without defacing it, without either... Do what now?
Could be on the back of that. The full purpose.
Yeah, it would be. So that's my question. I've seen one, and in the past I've ridden with law enforcement officers and seen them. It's correct. You can order them online, but you would either have to drill something into one of these badges and permanently attach it, or somehow weld it or something like that on. I'm not sure how you could permanently attach it to a badge.
Peak.
To the leader, I understand the concerns you have about someone maybe even being stolen. I get that. Actually, I have that same concern being used. But have we heard from law enforcement community? Are they really concerned? Is there a real concern that their badge would be defaced by having retired on there? Did y'all chat with anyone? Is that a concern at all?
I'm happy to further investigate this. To the question of defacement, in order to mount this, you'd have to deface it to mount it. You would have to, once you drill a hole, if you're going to mount it, the issue of it being in a glass case versus coming out of a glass case, all you have to do is break the case. My point is this. We currently permit a very limited number of people to do this. According to the terms, the very plain terms of this bill, we are expanding this to a dramatic number of people. There are no limits on the rank. There are no limits on what the only limit is that you're post-certified, but we in this body actually a few weeks ago expanded who is post-certified. My point is that post-certification, while important, does not limit the number of people who will suddenly have the ability to carry these badges, and I don't believe every person will do it with ill intent. My point is that once you are retired, if we're going to allow you to retain a memento, that memento should have some designation that says that this is a memento and is no longer an active badge, because not everyone is going to stop when you're pulled over. Not everyone's going to know to call in or to figure out whether this is a legitimate or illegitimate or whether it's been stolen. And so this is a way to strike a balance between safety and celebration.
And I get that, and I get the concern. I really do. I think it'd be prudent to hear from the law enforcement community. Are they they're going to be. We're saying they can keep this badge, but all of a sudden we're going to defame it by putting something on it. I just would love to hear from them. Are they okay with that? That's what my point.
And I hear your concern. I will say that right now they can't keep it, and so I think that we're shifting from not being able to keep it to being able to keep it with condition.
Yeah, with some mark on it though. So
I have a motion, Mr. Speaker, Mr. Chairman. Question.
Good idea. Oh. This discussion is about an amendment. The motion was, do we approve this amendment? All those in favor of this motion, raise your hand. Those opposed? The amendment fails. It's not appropriate. Okay. No. I'm putting it on the floor. All right, ready? Here we go. This is for tomorrow's calendar. Modified open SB 206. Any opposed? It's on. Hunter, I forgot you. Stop. That one's on. We're going to jump back on the wall. He showed up at 9:30 for this 9 o'clock meeting, so we'll let him.
Thank you, Mr. Chairman. We don't have such robust debate in our Rules Committee. I'm impressed. But I would like to bring to the committee Senate Bill 58, the Georgia Leadership and Service Admission Act. The purpose of the bill is for us as members, General Assembly members, to go out into our community and find those great candidates that are on the cusp of getting into one of our competitive colleges, and we basically ask them, are they willing to serve their country? And if they are, then we can help them through that process, and hopefully our letter of recommendation could help them get into one of our great colleges and universities here in the state.
My first question to you would be, does that mean that all 180 representatives and all 56 senators would have that right to make a recommendation?
Yes, sir.
Does that recommendation, does that jump any of those students up in front of the line?
Only if our colleges allow that, but it's not mandated.
What if all 200 and ever how many of us there are had one and we all wanted the same spot in that particular college?
Well, the idea is, oh, you mean we would have 238 different people?
Yes, sir, or 236. I wouldn't let the lieutenant governor have a...
Well,
okay, that's it.
Yes,
You've
sir.
got no other questions. Thank you.
Thank you. Appreciate it.
Okay, back to where I was. I did 206, right? There was no objection. Under modified open, SB 335. Any objection? Modified open, SB 336. Any objection? Did you notice I did both Mr. Black's bills, one right after the other? I just can't wait for him to come over to the house and present it. Oh, we've been through that, haven't we? I'm sorry. Senate resolution under modified open, 730. Any objection? It's on. On the back side, under modified structure, SB 193. Any objection? Modified structure, SB 263. Any objection? Modified structure, SB 269. Any objection? Modified structure, SB 331. Any objection? Modified structure, SB 364. Any objection? Modified structure, SB 402. Any objection? Modified structure, SR 558. Any objection? Modified structure, SR 954. Any objection? That's it.